Ready, start. All unoccupied lands are the property of the government, unless any person can establish his right or title to any such land. Full stop. This presumption available to the government, is not available to any person or individual. Full stop. The second difference is in regard to the period for which title and slash r possession have to be established by a person suing for declaration of title. Full stop. Establishing title slash possession for a period exceeding 12 years may be adequate to establish title in a declaratory suit against any individual. Full stop. On the other hand, title slash possession for a period exceeding 30 years will have to be established to succeed in a declaratory suit for title against government. Full stop. This follows from Article 112 of Limitation Act, 1963, which prescribes a longer period of 30 years as limitation in regard to suits by government as against the period of 12 years for suits by private individuals. Full stop. Government properties are spread over the entire state, and it is not always possible for the government to protect or safeguard its properties from encroachments. Full stop. Many a time, its own officers who are expected to protect its properties and maintain proper records, either due to negligence or collusion, create entries in records to help private parties, to lay claim of ownership or possession against the government. Full stop. Any loss of government property is ultimately the loss to the community. Full stop. Courts owe a duty to be vigilant to ensure that public property is not converted into private property by unscrupulous elements. Full stop. Many civil courts deal with suits for declaration of title and injunction against government, in a casual manner, ignoring or overlooking the special features relating to the government properties. Full stop. Instances of such suits against government being routinely decreed, either ex parte or for want of proper contest, merely acting upon the oral assertions of plaintiffs or stray revenue entries are common. Full stop. Whether the government contests the suit or not, before a suit for declaration of title against a government is decreed, the plaintiff should establish, either his title by producing the title deeds which satisfactorily trace title for a minimum period of 30 years prior to the date of the suit, within bracket, except where title is claimed with reference to a grant or transfer by the government or a statutory development authority, bracket close, or by establishing adverse possession for a period of more than 30 years. Full stop. In such suits, courts cannot, ignoring the presumptions available in favor of the government, grant declaratory or injunctive decrees against the government by relying upon one of the principles underlying pleadings that plain governments which are not denied or traversed are deemed to have been accepted or admitted. Full stop. A court should necessarily seek an answer to the following question, before it grants a decree declaring title against the government, whether the plaintiff has produced title deeds tracing the title for a period of more than 30 years, or whether the plaintiff has established his adverse possession to the knowledge of the government for a period of more than 30 years. Full stop.